someone could hear me earlier. Can
Yes, we can hear you.
Okay, thank you, sir.
Inform us what's going on here and be able to clearly state what's going on here.
Right.
And that's the real problem, is that they historically clearly
Jason Holzman.
Good morning, Commissioner. in the matter of the application of Confluence Rivers Utility Operating Company, Inc., for authority to acquire certain water and sewer assets and for a certificate of convenience and necessity. This is file number WA-2019-0299. My name is Charles Hatcher, and I am the regulatory law judge presiding over this hearing. Let's go ahead and have counsel for the parties make their entries of appearance for Confluence Rivers.
Thank you, Judge. Dean Cooper and Jennifer Hernandez appearing for Confluence Rivers Utility Operating Company, Inc. We're from the law firm of Bride & Swearingen in England, PC, P.O. Box 456, Jefferson City, Missouri, 65102.
Thank you. And for staff?
Karen Bretz and Mark Johnson for staff of the commission. Our address is 200 Madison Street, P.O. Box 360, Jefferson City, 65102.
Thank you. And for the Office of the Public Counsel?
John Kleiser appearing on behalf of the Office of Public Counsel. Our offices is also at 200 Madison Street, Suite 650, Jefferson City, Missouri, 65101.
Thank you. And for the Lake Perry lot owners?
Good morning, Judge. This is David Linton on behalf of the Lake Perry Lot Owners Association. I'm with the law firm of McCarthy, Leonard, and Kammerer. My address is 314 Romaine Spring View, Fenton, Missouri, 63026.
Thank you. A couple of initial remarks. This is the WebEx version of those remarks. Again, I'm going to remind everyone to please mute themselves. I also have control as host of the meeting, so I have muted everyone to stop that feedback. When counsel, you need to speak, or your witnesses need to speak, just unmute yourself in the normal course of business, and that will also unmute my unmuting of you. Sorry, that was wordy. We will proceed slowly at every step of this hearing because of that muting issue, and because this is the first time the commission has performed a hearing like this over the internet solely. And I also want to remind the parties, the witnesses, anyone on this call, that the chat function that's down in the lower right-hand corner of your WebEx app box is not private. It will print out at the end of the meeting. So please use that cautiously. Do we have any preliminary matters from the parties?
Your Honor, actually, I probably can wait until after opening.
Okay, anyone else? Okay, then the order of opening statements and witnesses will follow the joint recommendation by the parties, and that will be Confluence Rivers first, staff second, public counsel third, and the lot owners bringing up the rear. And with the exhibits, we will continue the procedure we talked about in the pre-hearing conference, and we will submit those, and then myself will take care of resubmitting those to the court reporter after the hearing. Let's go ahead and get to opening statements then. Mr. Cooper for Confluence Rivers.
Thank you, Your Honor. Again, Dean Cooper appearing on behalf of Confluence Rivers. The first issue that's been identified by the parties in this case is to determine the net book value of the water and sewer assets of Port Perry Service Company for purposes of this case. The net book value for the Port Perry assets that is supported by Confluence Rivers as of December 31st of 2019 is a total of $77,936. That's $20,070 for the water assets and $57,866 for the sewer assets. This is the same net book value that staff proposes in its testimony and the same net book value agreed to by staff, the Office of the Public Counsel, and Confluence Rivers in the stipulation and agreement as to net book value that was filed on April 9th of 2020. Association witness Mr. DeWilde also agrees to this amount in his rebuttal testimony. For comparison, as of direct testimony in the base case, staff had indicated its belief that book value was a total of $58,133 for water and sewer assets combined. Most of the difference between those numbers is on the water asset side. Thus, there's about $20,000 more in net book value agreed to today than was before the commission in the base case. The acquisition premium assumed today, thus, is smaller than what was assumed at the time of the first hearing. The second issue identified by the parties is, given that $77,936 net book value, should the commission find the proposed transaction to not be detrimental to the public interest? Confluence Rivers believes that the identified net book value is neither a detriment unto itself nor supports any finding of detriment related to this transaction. First, the net book value does not change as a result of a transfer of ownership. Thus, the number itself cannot be a detriment associated with the proposed transaction. Second, Confluence Rivers has not requested an acquisition premium in this case and has formally waived any opportunity to recover acquisition premium that it might have in subsequent rate proceedings related to the Port Perry assets. This waiver was memorialized in a March 4, 2020 pleading. Thus, any premium that would be paid by Confluence Rivers will not result in a detriment to the public interest because Confluence Rivers will not recover in customer rates any premium amount paid. Third, Confluence Rivers will be able to provide safe and reliable water and sewer service to the Lake Perry community without recovery of any acquisition premium as a result of this transaction. The Central States Water Resources family of companies currently provides water or sewer service to over 35,000 customers, serving more than 100,000 people across 4 states. Central States and its utility operating affiliates have $63 million approximately of total capital investment across 172 water and sewer systems. The 4 states I mentioned are Missouri, Kentucky, Louisiana, and Arkansas. That includes approximately $4.6 million in investment in Confluence River's existing 9 water and 9 sewer systems. Confluence Rivers has the technical, managerial, and financial resources to own and operate the systems to be acquired and to otherwise provide safe and adequate service on a going forward basis. Therefore, Confluence Rivers asks that the commission approve the proposed transaction. Thank you.
Thank you. And Ms. Bretz for staff.
Good morning. May it please the commission. This case comes before you a second time for the limited purpose of providing the commission with information regarding the net book value of the Port Perry Service Company's water and wastewater assets. In doing this, the parties present 2 issues to the commission. The first is, what is the net book value of the Port Perry assets? On this, the parties agree. The net book value of the systems is $77,936 as of December 31st, 2019. This breaks down to $20,070 for the water assets and $57,866 for the wastewater assets. Staff witness Kim Bolin testifies in her pre-filed testimony that in preparing this net book value calculation, staff requested further financial information from Confluence in order to update staff's original calculation. Confluence provided this information and made it available to all parties. Staff met with the Office of Public Counsel and further refined the calculation. As I just said, all parties agree to this net book value. The second issue is, given this net book value, should the Commission find that Confluence River's acquisition of these assets is not detrimental to the public interest and approve the transaction? Staff's position is that the transfer of assets is not detrimental to the public interest and that the Commission should approve it. The determination of net book value does not change that position. Our reasoning is straightforward. Confluence has unequivocally stated that it waives any acquisition premium. Confluence stated this at least twice in a filing made March 4th, 2020, and in Josiah Cox's pre-filed rebuttal testimony. Mr. Cox testified in his pre-filed testimony that Confluence will charge its Commission-approved 2002 rates under the current tariff until the system's next rate case. At the next rate case, the agreed upon value of $77,936 net book value will be a starting point for setting rate base. In their position statements, the lot owners and the Office of Public Counsel contend that Confluence is overpaying for these systems. They argue that the price Confluence will prospectively pay is detrimental. However, staff points out that net book value is used to determine the value of rate base for setting rates. Net book value does not necessarily reflect market value. Finally, while Confluence is paying more than net book value for these systems, it is staff's position that Confluence has the financial capability to purchase them at the agreed-to purchase price without recouping a premium from the Port Perry ratepayers. This transaction is not detrimental to the public interest, and the Commission must allow it to proceed. Kim Bullen is available to testify by video for cross-examination and to answer Commission questions. Further, James Bush and Natel Dietrich, who testified at the initial hearing, can be made available if the Commission wishes. Thank you.
Thank you. And Mr. Kleiser for the Office of the Public Counsel.
Thank you, Your Honor. May it please the Commission. As you've heard, there are two issues before the Commission today. The first is the net book value of the Port Perry system. This is not really in dispute, however. All the parties into this case have come to an agreement as to the dollar amounts of these net book values, and those dollar amounts are what were agreed to by 3 of the 4 parties in the stipulation and agreement on net book value that has been filed in the briefs. So I would simply therefore ask the Commission to find those values to be correct. The second issue is whether the acquisition of the Port Perry system by Confluence Rivers is detrimental to the public interest given the net book value. The OPC has previously argued that the acquisition of the Port Perry system by Confluence Rivers is detrimental to the public interest, and nothing about the agreement as to the proper net book value of the system changes this. The Commission cannot and should not ignore the simple fact that approving this acquisition will invariably lead to customers of Port Perry paying far more than they would otherwise need to for the same level of service. Confluence Rivers is coming back for another rate case in the near future. When Confluence comes back, they will be asking to recover massive capital expenditures related to their other systems. The Commission knows this because the Commission itself asked about this during the on-the-record presentation of the stipulation agreement reached in Confluence's last rate case. At the same time, the company will almost certainly seek to consolidate Port Perry with the rest of Confluence's rates, just as it did with all of its other systems. The ultimate outcome will be that Port Perry customers will end up paying 2 or 3 times more than what they otherwise would have to pay if Confluence did not receive the system. Just anything different is at best inexcusable naivete and at worst a blatant lie. The egregious over-expenditure created by the difference between the net book value of the Port Perry system and the contract price Confluence Rivers entered into in this case only exacerbates this problem. A prudent utility company would never overpay for a system unless there was some untapped revenue stream that could be exploited. That generally means either room for substantial customer growth or room for substantial capital expenditure. At the moment, the Port Perry system has neither. Why then would Confluence operate in this manner? Why would it go to all the trouble of building an escape clause into its purchase contract if it still intends to pay more than twice the underlying price for the system? The answer is simple. Confluence Rivers must believe that it has the ability to later overinflate its return on investment in this system. I cannot tell you right now what exactly Confluence's ploy will be, but I do believe that Mr. Justice's testimony does an excellent job of laying out the various ways Confluence may seek to make up the difference. In any event, this commission should not give Confluence Rivers the opportunity to pull the wool over its eyes by approving this transaction. Instead, this commission should listen to the will of the public and deny this transaction so that a much better and more reasonable company can step in to take Confluence's place. Thank you.
Thank you, Mr. Kleiser. And Mr. Linton for the Lake Perry lot owners.
Thank you, Your Honor. Good morning. May it please the commission. My name is David Linton and I represent the Lake Perry Lot Owners Association. We are here today because Confluence Rivers Utility Operating Company has filed an application with this commission to acquire the assets of Port Perry Service Company, which provides water and sewer services to my client, the Homeowners Association. After holding a hearing for Confluence Rivers to present its testimony on October 7th and 8th of last year, the commission determined that the Confluence Rivers had not provided the commission all the necessary and essential issues for it to make a determination. Therefore, it provided a second round of hearings, and that is why we are here today. Despite having a second bite at this apple, Confluence Rivers is no closer now to carrying its burden of proof in this case than it was last October. We do have a net book value calculation that is agreeable to all parties, as has been stated, $77,936. But we are no closer to understanding how that number indicates that the transaction is not detrimental to the public interest. Neither Confluence Rivers nor staff have given any supporting evidence for their mere conclusion that the transaction is not detrimental to the public interest and have taken many efforts to obscure that and prevent that information from being provided. However, the net book value does highlight some very serious detriments to the public interest. The purchase price is significantly, and I repeat, significantly higher than the net book value. While I won't state the actual purchase price here, I will observe that the purchase price is very high in relation to the net book value. While Confluence Rivers has not provided any evidence explaining the benefit to the public from such a high purchase price, the association has presented testimony from two expert witnesses that explain the disadvantage of a transaction having a purchase price that far surpasses the net book value. Mr. DeWilde is a CPA and provides business planning advice as part of his business. He observes that the acquisition premium, the difference between the net book value and the purchase price, typically represents an expression of the goodwill value of a business. There is no justification for such a significant acquisition premium in this case. He goes on to explain that Confluence Rivers' own prior testimony reveals that they did not intend to place themselves in such a risk of significant under-recovery from this transaction. He also explains how the excessive purchase price precluded more reasonable proposals from being considered. Finally, and most importantly, he explains how there are just too many remaining uncertainties arising from this transaction. Those many uncertainties make this transaction detrimental to the public interest. The second association expert witness is Glenn Justice. He explains the difficult situation Confluence Rivers has placed itself in by having such a significant non-recoverable acquisition premium. The bottom line from this second hearing is that Confluence Rivers has placed itself in a situation that has too many uncertainties and too many risks. The transaction is detrimental to the public interest because Confluence Rivers has placed itself in an untenable situation. and Confluence Rivers has not explained how it will handle those risks or uncertainties. Add to that the fact that the residents do not want Confluence River service. Confluence River's financing is still questionable, and Confluence Rivers will remove the management of the services from the community. All those factors indicate that this transaction will be detrimental to the public interest, and we request the commission deny the application. Thank you.
Thank you, Mr. Linton. I'd like to pause and remind everyone that we have one confidential piece of information in this case. Thus far, we have proceeded very well without mentioning that. If at some point any of the witnesses feel that they need to mention that piece of confidential information, please make it known a minute before you get to that part of your testimony, counsel. The same with any questions. It's going to take us a minute to go in camera and move all of the participants over to the WebEx lobby. So I just want to remind everyone as we get ready for witnesses, again, we'll go in the same order as recommended by the joint submission, and that will be Josiah Cox. Mr. Cox, if you could go ahead and unmute, I'm going to swear you in.
Judge,
I solemnly swear or affirm that the testimony you give in this hearing will be the truth.
I do.
Thank you. And Mr. Cooper, your witness.
Judge, before I get started, I would mention that Mr. Cox is in the same room with me, and because of that, and in order to try to avoid feedback, we're going to try to use my microphone for his testimony. So if you heard his affirmative response to your oath, okay, then we'll proceed in that way.
I heard him just fine. I'll listen for complaints as we go along.
Thank you, Judge. Mr. Cox, would you state your name?
My name is Josiah Cox,
By whom are you employed and in what capacity?
CSWR LLC, and I'm the president of the company.
Have you caused to be prepared for the purposes of this proceeding certain testimony in question and answer form?
I have.
Is it your understanding that that testimony has been marked as Exhibit 600 for identification?
It is.
Do you have any changes that you would like to make to that testimony at this time?
I do not.
If I ask you the questions which are contained in Exhibit 600 today, would your answers be the same?
They would.
Are those answers true and correct to the best of your information, knowledge, and belief?
They are.
Your Honor, I would offer Exhibit 600 into evidence and tender the witness for cross-examination.
Thank you. And when you offer Exhibit 600, that is also including Schedule JC1 and JC2, correct?
That is correct, Your Honor.
Thank you. Are there any objections to the admittance of Exhibit 600, Mr. Cox's pre-filed testimony? Hearing none, it is so admitted. Mr. Cooper, go ahead.
I believe that's all we have now, Your Honor. We have tendered Mr. Cox for cross-examination.
Thank you. And for cross-examination will be Ms. Bretz
We have nothing, Your Honor.
and Mr. Kleiser.
No cross, Your Honor. Thank you.
Thank you. And Mr. Linton.
No questions, Your Honor.
Thank you. I believe the second witness is
Your Honor.
Ms.
Your Honor, this is
Bolin.
Commissioner
Let's
Sylvie.
go ahead and have Ms. Bolin unmute herself.
Your Honor, I think Chairman is trying to get in touch with you.
Yeah, Your Honor,
Yes.
is this the appropriate time for commission questions of Mr. Cox?
Right after Mr. Linton goes, we'll have commissioner questions.
Okay.
All righty, thank you, Mr. Chairman. Mr. Linton, go ahead.
I have no questions, Your Honor.
Oh, I'm sorry. Yeah, you just said that. Yes, Commissioner questions.
Thank you, Your Honor. Commissioner Sylvie. Mr. Cox, why does Confluence want to purchase the system if the net book value is so far below the sales price and the company has stated that it will not seek an acquisition premium?
Yes, Chairman Sylvie, there are two reasons why we still want to consummate this transaction. One is that Port Perry is, the typical type of system that we specialize in. They're under 500 individual connections. And really, our company, our mission vision is to bring safe and reliable water resources to every community in the U.S. And small communities, particularly those under 500, they really represent the communities that are most at risk for a lack of safe and reliable service. In fact, the American Water Works Association in 2015 talked about how many safe water, clean drinking water violations were there. 80,000. Of those 80,000 violations, 70,000 of those were to communities with less than 500 connections. And really, of those violations, half of those are serious violations. So you think, E. coli in the water, a lack of, boil advisories, that kind of thing. And so those communities represent over 50% of the serious drinking water violations in the country. So we know that these are the type of communities that really need a professional utility provider, someone who's got industry experience, a financial, technical, and managerial wherewithal to manage them over a long period of time. So that's one reason. The second reason is if you think about from a total company perspective, the delta between the net book value and the floor purchase price is 0.24% of our current investment in property, plant, and equipment. From a Confluence River standpoint, it's 3.9% of our total investment in property, plant, and equipment. And Confluence Rivers is continuing to acquire systems under the same company. So we know that we have the wherewithal to be able to deal with this system. We know that we're the right company to be able to provide safe, reliable service for these customers. So that's why.
Thank you, Mr. Cox. And if the acquisition is approved, when would you anticipate coming in for a rate case for Port Perry?
That's really dependent on some other acquisition cases that we have going on now, but it will be at least 12 months. I can't imagine being any earlier than that, and possibly even longer, depending on how other acquisitions go and our investment in Port Perry and our investment in the other systems we're purchasing under Confluence Rivers.
Okay, thank you, Mr. Cox. Thank you, Your Honor. Judge, I believe you're still muted.
Thanks, Mr. Chairman. Any other commissioner questions? Okay, let's move to recross examination after the chairman's questions. Let's first go to staff, Ms. Bretz.
Nothing, thank you.
And Mr. Kleiser for public counsel.
Nothing, Your Honor. Thank you.
And Mr. Linton, any recross?
No questions, Your Honor.
And that brings us back to Mr. Cooper for redirect.
Yes, I do have some redirect. And in fact, Judge, I'm going to send to you, I guess, what are potential exhibits, and I will copy the other counsel on those.
And while you're doing that, and before Mr. Cox gets started, could we have him move maybe a little bit closer to the microphone?
We certainly can.
Okay. Okay, I've just received Exhibit 601C, and for everyone's benefit, the C stands for confidential. And this is labeled recent Missouri small water and sewer transactions. Let me forward this on my end, Mr. Cooper, before we get started. Okay, I have forwarded that to the commissioners. They should be receiving that in their email in just a moment. So, Mr. Cooper, if you'd like to go ahead with your redirect.
Your Honor, this is David Linton. I have not received that.
Oh, then let's wait a second.
Mr. Cooper, did you send that to my MLK address?
Oh, I sent it to that JD address that we use quite a bit, but let me see if I can forward it to the other address. Hold on just a second.
While we're doing that, I understand that Commissioner Holzman has a question for Mr. Cox. Commissioner Holzman, are you there? Commissioner Holzman is calling back in. Mr. Cooper, while we're at a pause, are you looking to offer these additional documents into evidence?
It's likely that I will, but after some foundations provided with my witness.
Okay. We'll circle back around after that foundation is laid, and I'll ask for objections if you move to admit it at that point.
Thank you.
Judge Hatch,
Yes, Commissioner Holzman.
for some reason, I don't know why, but you couldn't hear me at any time, and my phone was off mute, so I had to hang up and call back in. I apologize
I'm
for that.
sorry about that. Please go ahead.
Do I have an opportunity to ask a question?
Yes, absolutely.
Okay. Mr. Cox,
Judge, we're not able to hear that.
Yeah, I'm sorry, Commissioner Holzman. That was breaking up. I wasn't able to hear that either.
Okay. How about this? Is that better?
Yes, perfect.
Okay. Thank you. Sorry about the communication issue. Can you tell us ways in which you could recover those additional costs over net book value if you do not seek a premium?
Yes, sir. We're not looking to recover anything that's a premium at all.
I know I'm not asking you that if you are or not looking for it. I'm asking you if you were going to, can you tell me ways in which you could?
I have no idea how we could recover a premium like that. for rate making purposes.
Without being granted one. So you're not able. I'm asking if it's possible for you to bolster the request in other ways that would make up the difference in the cost versus net book value.
No, Commissioner, none that I'm aware of. Like I said before, the reason why we're willing to proceed with this transaction is it fits within our wheelhouse in terms of the type of communities we're experts at serving, and from an overall company perspective, the premium is such a small part of our overall company. Like I said, 0.24% of the overall company and only 3.29% of Confluence Rivers. So we don't have to. There's not an impetus on the company to have to recover that.
Okay. All right. Thank you very much. Thank you, Judge. Appreciate it.
Not a problem, Commissioner Holzman. Let's get back to our exhibit first. Mr. Cooper, have
You ended up being muted, Judge.
Yeah. Sorry, Mr. Linton, have you received a copy of the exhibit yet?
I have. Thank you.
Okay. And I will hear from public counsel or staff if they have not. So with Mr. Cooper, if I could put a pause in your redirect, I'd like to go back and ask, based on Commissioner Holzman's questions, if any of the parties have any. Okay, thank you. I see Mr. Cooper nodding his assent. So based on Commissioner Holzman's questions, are there any cross-examination questions from staff?
No, thank you.
From public counsel?
No, Your Honor. Thank you.
Thank you. And Mr. Linton?
No, Your Honor.
Thank you. And we are back to a pending Exhibit 601. Mr. Cooper, the floor is yours.
Thank you, Your Honor. Mr. Cox, in a question from the chairman, there was a reference to the significance of the premium in this case. Do you remember that?
I do.
Do you follow water and sewer asset purchases?
Your Honor, I am going to interpose an objection, and I'll try to do it once. And just looking at these exhibits, it'll be a continuing objection because I can see where counsel is going with this. This is beyond the scope of the direct testimony. There was no evidence of anything like this. The entire evidence of Mr. Cox was entirely on the calculation of the net book value, and this skirts the rules of testimony, direct testimony followed by rebuttal testimony. And my client has not had an opportunity to review this or prepare any kind of a response for this. So I object because it's beyond the scope of the direct testimony.
Mr. Cooper?
Judge, I don't believe that what Mr. Linton is citing as the reason for his objection applies. We're talking about redirect in this situation based upon questions that have been received by the witness. Certainly, had the witness received no questions, we wouldn't be moving down this road. But since he has, I think we are allowed to flush that out on redirect.
Remind me what the question was that opened this?
Well, I believe the chairman had referred to the significance of the premium, and so we want to address whether that really is significant or not. As to 601C, I think Mr. Cox also, and I'll jump ahead to 602, Mr. Cox also referenced in regard to, in his answer, the sort of the impact of that premium in relation to the other assets of the company and the family of companies. And so 602C will flush that out and explain where that comes from.
Your Honor, just in response, if the questions from the commissioners had been questions from the parties, I would have objected. However, out of deference to the chairman particularly and the other commissioners, I have, as is normal practice, not objected to their questions, giving them deference to their questions. So to the extent that Mr. Cooper is basing his questions on commissioners' questions, I would renew my objection and say under ordinary circumstances, those are objectionable questions and that they go beyond the scope of direct testimony.
Okay, and would staff like to weigh in?
No, we have no objection to entering the exhibits into evidence.
And Mr. Kleiser, any objections from the Office of the Public Counsel?
I believe that the OPC would be objecting to 601, but not necessarily on the same grounds that Mr. Litton raised. I was going to wait until the offer of the exhibit in and of itself. I don't know if you want to proceed that way or if you'd like me to make my objection now. I would like to hear the foundation first, to be honest.
No, that's fine. Mr. Linton, I'm going to overrule your objection and allow Mr. Cooper to proceed. Go ahead.
Thank you, Your Honor. Just to remind where we started, that we had talked about the fact that there was a reference to the significance of the premium in this transaction. Do you remember that, Mr. Cox?
I do.
And do you follow water and sewer asset purchases both in Missouri and elsewhere in the United States?
We do.
Is it common in water and sewer acquisitions involving companies other than Central States affiliates for there to be an acquisition premium paid by the purchaser?
Yes, it's very common across the entire country.
In assessing the reasonableness of a purchase price, are there measures other than acquisition premium used by purchasers within the water and sewer industry?
Yes, it's standard across the industry to use a purchase price per customer is a metric that's kind of industry standard.
Have you had the opportunity to compare any recent Missouri transactions to the Port Perry transaction in terms of price per customer?
I have. I've pulled up 4 recent transactions, both Missouri American Water and their pending purchase of Hallsville, Missouri, Missouri American Water on their purchase of Lawson, Missouri, and Liberty Utilities purchase of Franklin County Water, and the Missouri American Water's purchase of Wardsville, Missouri.
Your Honor, this is Dave Linton, and I hope this will be my last time I object, but we've gone from questions from the chairman asking the acquisition premium and why Confluence Rivers still wanted to acquire the facilities, and Commissioner Holzman's question about are there other ways of recovering these, and now we're giving an entire analysis of other companies, other acquisitions, and I still say that's out of the scope of the direct testimony and outside the scope of the questions from the commissioners.
Mr. Cooper, would you like to respond?
Well, my response will be similar to previous. I mean, I think that there was a sort of an assumption that the premium, that the price being paid is somehow significant because of the premium. And you can tell from the exhibit, and not too many more questions, we're going to finish providing the foundation for some information that, at least for the commission's benefit, would explain the purchase price to some extent and its reasonableness for that matter.
Would staff like to weigh in?
We continue to have no objection to the entry of these exhibits.
And Mr. Kleiser, would you like to comment?
I'll go ahead and weigh in now. Some of this might be echoing exactly what Mr. Litton said, but I do believe that 601 is outside the scope of the questions asked by the commission. The issue before us is the adequacy or the prudence of the acquisition adjustments, which is something that's apparently addressed in 602. I'll concede that. But 601 isn't addressing acquisition premiums in any regard. There's no comparison between net book value and what was actually paid for the systems. It's purely a comparison between the price paid per customer, which is a completely different metric and one that would require significantly different assessment to go along. This is nothing to do with the acquisition adjustment premium. He's exclusively presenting this so that he can make an argument that it must be reasonable because, look, other companies paid more per customer. But that's not the basis upon which companies buy or sell systems. It's the basis of what is the value of the underlying system that matters, which is not addressed in 601. That would be my objection.
Actually, Your Honor, Mr. Cox has indicated that per customer prices are a basis for the buying and selling of water and sewer systems.
I would agree, Mr. Cooper. To my mind, it seems like there could be many business rationales. And if Mr. Cox is explaining a business rationale and how it is producing or why it's producing an acquisition premium, then I do think that's relevant. I'm going to let that continue. Go ahead.
Your Honor.
For the record, then, just record, this is David Lynn, just for the record,
Yes.
then record this as a continuing objection.
Thank you, Mr. Linton. Denied. Go ahead, Mr. Cooper.
Sorry, Your Honor.
Yes.
OPC. I'm sorry. The OPC would like to ask for an opportunity to submit information on this exhibit then by including or updating this exhibit with the actual net book value of the acquisitions being performed here. We would make that filing obviously after this because we were not aware of this exhibit, so we were not able to prepare those numbers beforehand. It would simply be a late filed exhibit.
Are there any objections to what public counsel proposes?
Yes, Your Honor. I mean, we're just continuing beyond the scope of the hearing that's been set. We've talked about before, and others will remind you again, I'm sure, in briefs as a result of this hearing, that the company has the burden in this matter. I don't think there's anything improper about, given that, the company having the last say with its testimony. It's just not. It's not required and it's not necessary for every piece of evidence that comes in the hearing to receive an additional opportunity to respond.
May I respond to that, Your Honor?
Yes, go ahead.
Let me just point out the utter ridiculousness of the situation that's now come up. Basically, Confluence is attempting to submit a piece of evidence based on a question regarding acquisition premiums that doesn't actually address acquisition premiums. And all the OPC would like to do is to update that evidence to directly address acquisition premiums, which again is the basis of the question upon which the evidence is attempting to be submitted.
Mr. Cooper, it does seem to me like you're trying to have it both ways.
I'm certainly not going to agree with that, but I understand you will issue a ruling one way or the other. So,
okay, let's see where this gets us. The exhibit hasn't been offered into evidence yet. Mr. Kleiser, I am inclined to grant your request, but it's a little premature at this point. Let's let Mr. Cooper and Mr. Cox conclude, and then we'll see where we're at with the exhibits. Mr. Cooper, go ahead.
Thank you, Your Honor. Mr. Cox, in keeping in mind that this exhibit's been marked confidential, really, I think, because of only the CSWR column on there, and potentially the Franklin County water column. Could you describe for us what's represented in Exhibit 601C?
Yes, what you have there is a description of the acquiring utility, the system that they're acquiring, and then what type of service that system provides, whether that's sewer or water and sewer. and then it gives a total customer basis. That's both combined water and sewer customers. And then it has the purchase price for those systems.
So that line that says customers, maybe you could also call it connections.
That is correct. It's connections.
Okay. And the bottom line then represents the calculation of the price per customer for each of those transactions. Is that correct?
That is correct.
And some of that information is available because several of these are acquisitions involving public entities, correct?
That is correct.
Okay. Do you also have in front of you Exhibit 602C?
I do.
And during questions from Chairman Sylvie, I believe you indicated the sort of the relative size of the acquisition premium in regard to both the Central States Water Resources Company systems, assets, and the Confluence Rivers piece of those assets, correct?
That is correct.
And again, I think that because of this has been marked confidential because of the line that represents a acquisition premium or the difference from purchase price and between purchase price and net book value, correct?
That is correct.
Okay. Tell us what is shown on Exhibit 602C.
So in 602C, what you see is the total investment in property, plant, equipment by Central States Water Resources in whole. And also you have the Confluence Rivers investment in property, plant, equipment. Next, you have represented the stipulation agreement on the net book value between all the parties. And then we have the stipulation agreement minus the floor price in the contract. So that's the premium that we keep mentioning here. And then the final line in that is a measure of that premium as total in terms of total investment by the companies in property, plant, and equipment.
So it represents a comparison of essentially the significance of that acquisition premium against the existing assets of the whole family of companies and Confluence Rivers, correct?
That is correct.
And at the top of the sheet, you have listed customer numbers or connections. Is that correct?
That is correct.
And so today, Central States family of companies has 35,000 approximately, I would guess, because this probably changes, but 35,649 customers.
That is correct. And you're right, it does change. I mean, we're closing systems on Friday, so that number is dynamic.
And then Confluence Rivers, the same thing. That's its portion of those family of company customers, right?
That is correct.
I guess one of the facts that feeds into that, I guess when we talk about the customer numbers for Central States as a whole, how many individual water and wastewater systems does that represent?
We have 172 water and wastewater systems across 4 states.
Going back to Exhibit 601C just for a moment, we talked about the last line being a comparison of the price per customer in those various transactions. How does, without revealing the number, how does the Central States or the Confluence Rivers purchase of Port Perry compare to those others on your list?
I mean, it's radically smaller. It is, from the lowest transaction we mentioned is less than half. For most of the transactions, it's, 1/11th, 1/12th the price that per customer that other utilities are buying systems for.
You were also asked about how long it would be until the next rate case for Confluence Rivers, correct?
Yes.
And in that, you mentioned that it would depend upon other acquisitions. Is there another acquisition case that's pending before the commission right now?
We do. We have another acquisition case in front of the commission currently.
And that's for Confluence Rivers specifically,
That is
correct?
correct. It's Confluence River's case.
And you may not remember this in a lot of detail, but approximately how many systems are involved in that acquisition case?
I believe it's 5 more systems.
Total, or I mean, if we count water and sewer separately, is it still, you think, 5 systems, or would it be more than that?
It's more than that if it's water and sewer separately. It's 5 companies we're buying the assets from.
One moment, Your Honor. Mr. Cox, in terms of those other transactions that you represented on 601C, I noticed that at least 3 of them, as I mentioned before, have to do with public entities, correct?
That is correct.
And do public entities account for their investments, their capital investments, in the same way as regulated entities?
They do not.
Does net book value have does it have the same meaning when you're talking about a public entity as it does with a regulated entity?
It does not, because they're not required to.
All right, Your Honor, I'm going to object at this point. We are definitely past the scope of redirect.
I tend to agree, Mr. Kleiser. Mr. Cooper?
Thank you, Your Honor. That's all the questions I have.
Okay. That seems to make the objection moot at this point. Mr. Cooper, we still have 2 exhibits that have not been offered nor admitted into evidence.
Yes, Your Honor. I'll do it. Well, I'll offer them both. I will offer 601C into evidence and 602C into evidence.
Let's take 602C first, and a reminder that these are confidential. Does anyone have any objections to Exhibit 602C being admitted into the hearing record?
Yes, Your Honor, this is David Linton. Just for the many reasons I've already objected, so I won't say anything more.
Thank you, Mr. Linton. Any other objections?
Your Honor, I have a potential objection, and this is somewhat difficult for me because my objection would be based on an understanding of the exhibit, which I'm not sure is correct. I would like, if possible, just to get some clarification regarding it, and that might remove the need for the exhibit. I don't know, this is a little unorthodox, I appreciate, but I'll simply pose my question and then, you can decide from there. And again, we're on 602, correct? I just want to make sure of that.
Yes.
The property, plant, and equipment, you see, what I thought I heard Mr. Cox testify was that was the investment Confluence has made in each of these systems, both the total CSWR and Confluence Rivers. Is that correct?
The first column is the CSWR companies as a whole. So that would include all the operating utilities. The second column would be only Confluence Rivers piece of that overall.
Yes, but what does the row mean? Property, plant, and equipment.
Because it's what we would normally represent as the utility plant that's owned by the company. I guess I'm a little confused by the question, but.
Well, no, I need to make sure what it is. Is it in fact what the company represents is the value of the existing plants?
Well, yes. I mean, it would be all those categories, but but yes, as recorded, per its investment.
So with or without depreciation?
Yeah, it would be net of depreciation, Mr. Kleiser, and the number would change tomorrow, right? So, but yes, it's net of depreciation as reflected.
And last thing, is that Confluence's investment, or for specifically the Confluence Rivers? You know what? Never mind. I realize now that I had something backwards. All right. Thank you. Actually, that does resolve my objection, so I don't need to make it. Those questions did help. Thank you very much.
All right. Thank you, Mr. Kleiser. I'm glad to take a detour to clear that up. Mr. Linton, your objection is overruled. Exhibit 602C is admitted onto the hearing record. Let's go to the more controversial 601C. This is the one labeled recent Missouri small water and sewer transactions. Mr. Cooper, did you already ask for that to be admitted also? Yes.
I believe I did. Yes.
Thank you, sir. Does anyone have any objections to the admittance of 601C?
Yes, Your Honor, Dave Linton, for the same reasons already expressed.
Thank you, Mr. Linton. Does anyone else have any objections to the admittance of 601C onto the hearing record?
Again, the OPC would object simply that it's beyond the scope of commission questions and therefore beyond the scope of redirect, as previously stated.
Mr. Cooper, where did these numbers come from?
They were compiled by Mr. Cox. As I mentioned before, the easier ones are Hallsville, Lawson, and Wardsville, because those are public entities. The numbers are public. Franklin County, Mr. Cox has knowledge of because of having been involved in the process.
Okay, Mr. Linton, your objection is overruled. I'm going to admit Exhibit 601C, and Mr. Kleiser, your objection is also overruled. I'm going to admit Exhibit 601C onto the hearing record. However, I'm going to add to that an allowance for Mr. Kleiser to update that table. And the reason I'm doing that is, Mr. Cooper, you provided a table which seems to imply a certain business rationale, but also it is missing some of the exact topics that we're talking about here that would make it a little bit more comparable to our situation. So the public counsel will be requested to update this exhibit with their information on net book value for each of these systems. Did I understand that request correctly, Mr. Kleiser?
Yes, and I'm honestly not sure that we will be able to, but we definitely will be looking into it and seeing if it's possible to, and we'll make that filing as soon as possible. So thank you.
Okay. Yes, go ahead.
Your Honor, and I don't know what this would look like, but since we're discussing it right now, will you provide an opportunity to respond to Mr. Kleiser's filing if he's allowed to do so, or if he does so?
Mr. Cooper, I would be reluctant to extend this out further. However, there is no operation of law date on your application. So if the company is willing to extend that by offering a response to Mr. Kleiser, I will allow it. Any other?
Apologies. I have no problem with this. And I was going to further add that for the record, I will try to reach out to Confluence Rivers before filing something to hopefully avoid any kind of discrepancy. I'm not sure if that's necessarily possible, but I will present the evidence such that we are able to find it.
I appreciate that and would probably appreciate a joint filing even more, but I'll leave that to the parties. Let's get back to our schedule. We have our second witness. Sorry, I've got to move my computer around here for a second. We have our second witness, Ms. Boleyn, getting ready to begin her testimony. So I'm going to swear her in after asking her to unmute her phone. Ms. Boleyn, would you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you. And direct exam by staff, please go ahead.
Thank you. Ms. Boland, will you please state your name and spell your last name for the record?
My name is Kimberly Bolin, and Bolin is spelled B-O-L-I-N.
By whom are you employed and in what capacity?
I am employed by the Missouri Public Service Commission, and I am the auditing department manager.
Are you the same Kimberly Bolin who prepared testimony in this matter, which has been marked as Staff Exhibit 800?
Yes, I am.
Do you have any changes or corrections to your testimony?
No, I do not.
Is your testimony true and correct to the best of your knowledge?
Yes, it is.
If I were to ask you those same questions today, would your answers be substantially the same?
Yes, they would.
Judge, we offer Exhibit 800 into evidence.
Are there any objections to the admittance of Exhibit 800 onto the hearing record? Hearing none, it is so admitted. Go ahead.
And we tender Ms. Bolin for cross-examination.
Thank you. And let me check my order of cross-examination. Mr. Cooper, you are first up.
Thank you, Your Honor. On pages 5 and 6 of your testimony, you discuss the fact that Confluence Rivers has stated that it will not seek to recover acquisition premium and that it will not recoup any premium paid. Is that correct?
That is correct.
First, when we're talking about a regulated utility, the net book value for that regulated utility or its net original cost doesn't change merely because ownership changes, does it?
That is correct.
And I believe you would agree, maybe we already touched on it, that Confluence Rivers in this case has in fact formally stated that it will not seek to recover acquisition premium for the Port Perry assets. Is that correct?
Yes, it is.
Mr. Cooper, this is all covered in her pre-filed testimony, correct?
It is. I'm getting I'm setting the foundation, I guess, for the follow-up questions.
Okay, go ahead.
Ms. Bolin, are you familiar with any time where the Missouri Commission has granted a water or sewer utility recovery of acquisition premium and rates?
I personally am not.
So it's safe to say then that you certainly have never seen a situation where utility has been allowed to recover acquisition premium and rates after a waiver such as the one that Confluence Rivers has in this case, correct?
I would say so, yes, correct.
If there is no recovery of acquisition premium by the purchasing utility and rates, does the size of the acquisition premium matter from a rate-making perspective?
No, we will use net book value as the starting point for rate-making purposes.
And if there's zero for the acquisition premium, then it's zero no matter where you started from, correct?
Correct.
For the purposes of setting rates to be paid by the customers, correct?
Yes, for purpose of setting rates.
That's all the questions I have, Your Honor.
Thank you. And Mr. Kleiser.
I have no questions. Thank you, Your Honor.
Thank you. And Mr. Linton.
No questions, Your Honor.
Thank you. And now we turn to commissioner questions. Are there any commissioner questions? Okay, hearing none. We will move on to the next witness. You all would bear with me while I get my computer going again. I believe the next witness is Glenn Justice. Thank you all for your patience. I do appreciate that. Mr. Paul Glendon Justice Jr., please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you, and go ahead with direct examination, Mr. Linton.
Good morning, Mr. Justice.
Good morning.
Would you please state your name and your business affiliation for the record?
Yes, my name is Glenn Justice. I work for Experience On Demand LLC. I am a senior partner there.
And what is your business address?
It is 16020 Swingley Ridge Road, Suite 240, Chesterfield, Missouri, 63017.
And on whose behalf are you testifying today?
The Lake Perry Lot Owners Association.
Now, did you prepare or have to be prepared what has been marked as exhibits 700C and 700?
Yes, I did.
And those are in the form of questions and answers, correct?
That is correct.
If I were to ask you those questions today, would your answers be the same?
They would.
Do you have any corrections, changes to make to that?
I do not.
Okay. With that, I move for the admission of exhibit number 700 and 700C and tender the witness for cross-examination.
Thank you. Are there any objections to the admittance of exhibit 700C and 700P? Hearing no objections, exhibit 700, the confidential and public versions, are admitted onto the hearing record. The witness is tendered for cross-examination, which by my order brings up the public counsel. Mr. Kleiser.
The Office of Public Counsel has no cross-examination. Thank you, Your Honor.
Thank you. And that goes to staff. Ms. Spretz.
We don't have any either.
Thank you. And that goes to Mr. Cooper.
No questions, Your Honor.
Thank you. And that will speed us right along to our next witness. And this is the final witness, Richard DeWilde. And Mr. DeWilde, please raise your right hand. Do you solemnly swear or affirm that the testimony you give in this hearing will be the truth?
I do.
Thank you, sir. And the direct examination, Mr. Litton.
Good morning, Mr. DeWilde.
Good morning.
Would you please state your name and your business affiliation for the record?
My name is Richard DeWilde. I'm a CPA here in Perryville, Missouri, and I also manage the Lake Perry Lot Owners Association.
On whose behalf are you testifying today?
Lake Perry Lot Owners Association.
Did you have reason to prepare or cause to be prepared exhibits that have been marked as exhibit number 701 and 701C?
I have, yes.
And those exhibits are in the form of questions and answers?
They are.
If I were to ask you those questions today, would your answers be the same?
Yes, they would.
Do you have any changes to make to those questions and answers?
I do not.
Okay. With that, I move for the admission of exhibit number 701 and 701C and tender the witness for cross-examination.
Thank you. And on cross-examination, I believe we have public counsel. Mr. Kleiser, do you have any questions?
I have no questions. Thank you, Your Honor.
And for staff, does Ms. Bretz have any questions?
No, thank you.
And for Confluence Rivers?
No questions, Your Honor.
Okay, and any commissioner questions? I will go ahead and start off. I do have one. I would like to repeat Commissioner Holzman's question from earlier. Mr. DeWilde, can you walk me through some of the ways that Confluence could recover their investment here?
Listening to all the evidence that we've had today, and I don't believe there's any recovery available for the acquisition premium. Did you hear that, Judge?
Yes. Is that the end of your answer?
Basically, yes. I mean, that the question, as I understood it, was from you, if there was a way to recover that acquisition premium. Is that correct?
I believe the commissioner was trying to get into your description, and maybe I have the wrong witness. This might have been Mr. Justice's, but the walkthrough of the various scenarios of how the lot owners have envisioned that Confluence may attempt to recover the acquisition premium indirectly. Maybe that's a better.
A lot of that, I think, was Mr. Justice's information as far as that goes, but I can address that. The Lot Owners Association is very concerned with this being an economic transaction. With as many continual purchases that Confluence has made, it becomes a point when how many additional acquisition premiums can you pay and be able to continue to operate? I do realize with the numbers that we were presented today, with what their percentage is of the acquisition premium to their total assets, which was a surprise to me. I hadn't heard that before. But even in light of that, economically, it's not very much of a standard in the business realm that we deal with to be paying that much of an acquisition premium and never be able to recover that. So in some way, they're going to have to recoup the cost that they've put into this. And our thinking is, because we don't look into their books, we can't do that actually, is that they do recover this in a way by getting investors involved and paying them a nice return on their investment, and then utilizing that expense for the interest to be part of the cost that they can use for rates in the future. So, and also by being able to subsidize a lot of their other entities that they buy. They said they had 172. If they have an acquisition premium on a bunch of those and are able then to subsidize the monies that are earned from a system like ours, which is not distressed, and forward that to the others to continue to make them liquid, I think that's part of what we're concerned with, most definitely.
Okay. Are there any other commissioner questions? Okay, let's go to recross. For Mr. DeWilde, first we'll go to Office of the Public Counsel, Mr. Kleiser.
No further recross, Your Honor. Thank you.
Thank you. And Ms. Bretz?
Nothing, thank you.
And Mr. Cooper?
No recross, Your Honor.
I'd like to push my luck for just 1 second. I would like to turn back to witness Justice. Commissioner Holzman was having some technical difficulties.
Your Honor, before we do that, I did not hear whether you admitted Exhibit 701 and 701C into evidence.
I did not, thank you. I believe I already asked for objections. I'm going to go ahead and ask one more time. Are there any objections to the admittance of Exhibit 701, confidential and public versions? This is Mr. DeWilde's pre-filed testimony. Ms. Bretz?
None.
Mr. Cooper?
No, Your Honor.
Mr. Kleiser?
No, Your Honor. Thank you.
Thank you. Exhibit 701, confidential and public versions are admitted onto the hearing record. If you all indulge me, I would like to make sure that I get this question asked of Mr. Justice also. Mr. Justice, you are still sworn in. Are there any other ways beyond acquisition premium that Confluence Rivers could recover their costs?
Yes, I would say there are ways that exist.
Could you describe some of those?
Well, an example of those are outlined in my testimony. I've itemized five different scenarios, and I think part of the issue here is almost I guess I would describe it as kind of a nomenclature issue. It is, I would say it's correct that the Commission and Confluence Rivers and all the parties involved have acknowledged that a explicit merger premium in the sense of a form of an adder to rate base is not going to be allowed. However, when you look at the basic economics and finances of any corporate entity, there are multiple ways their profitability can be changed or influenced. And those are that's what I have itemized in my testimony. So item number one is a situation where effectively the company could, in theory, use excessive leverage and effectively borrow the amount that they're overpaying for the assets, and then take those and basically transfer or expense the interest payments on that debt back to the customers as an operating expense. So through that mechanism, the company can effectively drive up its return on invested equity. The second approach would be to drive down operating expenses. So imagine day one, the company has a current set of rates in place, a set of current operating costs. It could, in theory, choose to drastically cut staff, reduce maintenance, or take other actions which in the short term would drive up profitability and cash flow. So that would be the second item. And ultimately, it would be there would be a timing issue between that point in time and when that imbalance in cost and service would actually become apparent through either a customer complaint or subsequent rate case. The third possibility is to engage in various forms of self-dealing. And I would say, in my opinion, Confluence Rivers is structured corporately in a way that lends itself to this. This is something that I had highlighted in my original round of testimony at the first hearing, where if, for example, it uses an affiliate to obtain administrative services, computer services, billing services, those types of services, and effectively overpays that affiliate and passes those costs through to the Lake Pier customers, from a corporate perspective and from the holding company perspective, it can effectively produce excessive profits to effectively make itself whole. And the fourth item is the company could, in theory, gold plate capital investments and basically put in place either unnecessary projects or projects done at a level of cost that's not necessary. And even though it may obtain a regulated return on that amount, because those costs are above what is necessary, it effectively can drive its profits up. The fifth item is to effectively attempt to socialize the premium across its footprint. That is a more complicated scenario, which I'm not prepared to talk about the details of that scenario, but I believe a socialization of the premium would be something the commission should be mindful of, that possibility. And then the sixth is really any kind of combination of the above methodologies.
Thank you for that. Now that I have reopened Mr. Justice's testimony, let's go through recross. And I have not forgotten, we have a redirect, Mr. Linton, for Mr. DeWilde after those commission questions I asked of him. I cut you off before we got back to you. So first, let's start with recross on my recent question of Mr. Justice. Mr. Kleiser, does Public Counsel have any recross?
No, Your Honor. Thank you.
Ms. Bretz, does staff have any recross?
No, thank you.
And Mr. Cooper?
No, thank you, Your Honor.
Thank you. And that closes out Mr. Justice's testimony. I'm sorry. Any redirect, Mr. Linton?
No questions, Your Honor.
Thank you. That will close out Mr. Justice's testimony. Now let's wrap up Mr. DeWilde's. We had gone through recross and we are now on redirect. Mr. Linton, any redirect of Mr. DeWilde?
I have no questions, Your Honor.
Thank you. Okay. Does everyone have their exhibits admitted? I have checked off my list that we have them all admitted, and we are currently, or in a moment, going to talk about a late filed exhibit from the Office of the Public Counsel. So does anybody need assistance filing their exhibits? I do not see any takers.
Judge, let me just clarify. When you say filing their exhibits, this goes back to what we talked about at the pre-hearing conference, that we'll turn around and file our exhibits in EFIS as hearing exhibits.
I was going to go ahead and take that responsibility for you.
Okay, perfect.
Okay. I will email the exhibits that you have supplied to me to our court reporter and make sure that they are properly entered. Out, please. Out. Sorry about that. Where were we?
Filing of the marked exhibits.
Yes, I will take care of that for all the parties and forward that on to the court reporter. We have the outstanding updated table that Mr. Kleiser has volunteered to take on. Mr. Kleiser, I'd like to give you a 1 week due date. So next Tuesday for a status report or for that filing, but I do not have a calendar in front of me. Can somebody tell me what next Tuesday's date is?
It's May 26th, Judge.
Thank you. May 26th will be our due date for a status report or for the filing of the updated table. Are there any other matters that we need to address before we adjourn?
Judge, going back to the table, I believe that Mr. Cooper wants an opportunity to respond to that. Staff would like the same opportunity to do that. And is there a possibility we could try to submit a joint filing?
Yes, Your Honor. I think where we'd like to be is Mr. Kleiser offered to have some conversation maybe before that filing. If we could have that conversation and then see where that leads us before we necessarily set out additional dates for response from our perspective anyway.
I like hearing that you all are going to try and work that out. That works for the commission. Why don't I give a May 26th status update? Is that too soon, or would 2 weeks be more appropriate?
No, let's leave it shorter, Judge, if that's okay.
Okay. Status report filed by public counsel on the, or jointly, preferably, by the end of the 26th. And we will proceed with that from there on the late filed. Are there any other matters to be addressed?
We are, I guess, at some point, we probably need to talk about briefing, Your Honor. And I guess we were thinking something fairly short, such as 10 days for initial, 5 days for replies. But
I'm interested to see what the other parties have to say about the schedule.
That would be fine with the association.
For staff, does that sound doable?
Yes, that does. Yes, I'm sorry, it does.
Okay. And Mr. Kleiser?
I think I can make that work.
Okay, and just to repeat, Mr. Cooper, correct me if I'm wrong, that will be 10 days for your briefing and then 5 days for all others?
no, I was thinking that we would have all parties would file initial and reply.
And then 1 round of reply briefs. I'm following you now. And when would you like the 10 days to start? Because we also need to make sure that we consider our court reporter and her turnaround time.
I guess it depends on the answer to that question. I don't think I need 10 days from when the transcript is available. I just need a few days beyond when the transcript will be available. So. I think you're muted, Judge.
Sorry about that. Lisa, could you give us an estimate on turnaround time if we ask for this expedited? Lisa, you're muted. No. Yes, there you
Now,
are.
can you hear me? I have to have
Yes.
both, the phone and the computer. Okay, that's new. Sorry. So I have to work 2 jobs all day tomorrow and the next day, but I could do it over the weekend and have it for you guys on Tuesday. I mean, I could have it there on Monday, but I don't know. It's a holiday. I don't know if you guys will be there.
That's right. Let's call it then Tuesday, the 26th.
Okay,
For
perfect.
the
I'll have it.
transcript.
And I'll have the pre-hearing with that because it has to go volume before that. So you'll have that also.
All right, thank you. And counting my days then, Mr. Cooper, are you saying the 29th would be acceptable?
Yes, Your Honor.
Okay.
Your Honor?
Yes, Mr. Kleiser.
I would prefer if I had at least 1 weekend to potentially work on this if absolutely necessary. I apologize. Is it possible to go to the 2nd? Or first?
We're fine with that, Your Honor.
Any other objections for the 2nd? Hearing none, let's Go with first round of briefs due on the end of June 2nd. 2, 3, 5 business days. Put the reply briefs at June 9th, which is the next Tuesday. Do I have any objections to reply briefs being due the following Tuesday, June 9th? Mr. Cooper?
That's fine, Your Honor.
Okay. Hearing no objections, we shall do reply briefs on June 9th. Okay. Thank you all. Any other matters before we adjourn? Let's call. Thank you all. This hearing is adjourned. We are on the record.
Thank you, Judge.
Thanks all.